Hello, everyone. For those who just came in, my name is Dalia Anise. I'm an estate planning attorney with Legacy Life Plan. I am the founder of Legacy Life Plan. So before we get started, I just want to let you know that this is for educational purposes only. Everybody has a different family dynamics and different situations, and I advise you to go to an attorney to assist you with your estate plan. So we're going to talk about estate planning from according to Florida law. I am licensed in Florida. I'm also licensed in New Jersey, but I don't practice there. I practice only in Florida right now. Um, so let's get started with the presentation. Let me share my screen and we can get started with that. Today, we're going to talk about estate planning 101. Okay. Basic things about estate planning. I may delve a little bit deeper in there. Um, so, first, we're going to talk about the different documents that you need to have in place. Okay. Then we're going to talk about what really estate planning is all about. We're going to talk about probate, the difference between a will and a trust. We're going to talk about a lot of things. And at the end, I will give you a gift because I want to incentivize you. You are here for a reason. Okay. You didn't just decide, you're all very busy individuals. And you're attending today to know more about estate planning means there is a need and we tend to procrastinate. So I want to give you an incentive to do this for yourselves and your loved ones. So I will be offering a gift for you at the end of the presentation. All right. So let's talk about documents first. What documents does an individual need? An individual older than 18. Okay. If you're a minor, it's a different story. But once you're 18, you're considered an adult. Although in my book, sometimes an 18-year-old may not be an adult, but that's a different story. Um, so what are the documents? First thing we want to talk about is a will. A lot of people think that once they create a will, it's going to take care of them while they're alive. This is false. A will takes effect once I pass away. Okay. So what happens? My loved ones take my will, they deposit it with the court, they open probate if needed. If not, then probate is not needed. But even though if probate is not needed and I have a trust, you still need to deposit this will with the court. And yes, everybody who has a trust needs to also have a will. I get that question a lot. Um, a will is public record. Okay, so if you Google Jacqueline Onassis's will, it's going to be online, unfortunately, and it says what she did and who gets what. So a will is public record, and that's what a will does. It says, who do I give this to, how much, what the percentage are, and so forth. And if you have minor kids, you also write who their guardians would be if something happens to you. Next, I want to talk about a trust. So trust is an interesting vehicle that allows you, it works for you while you're alive and after you pass away to transfer wealth, to transfer assets to your loved ones, but it also takes care of you during your lifetime. And we're going to go a little bit deeper in what that means in a little bit. But this is just a general idea of the documents that you would need for estate planning. Healthcare directives. These are really important documents. Some people's like, well, you know what? I'm married. My husband will take care of everything. Not necessarily. Okay. Especially if you are not married, if you're single, these documents are extremely important. Even if you have children or siblings or so forth, even a significant other. I had someone tell me recently they were, he was together with his girlfriend for 30 years. And when she got dementia, the hospital threw him out. They refused to even let him in the room because she didn't have any documents to name him as healthcare surrogate, let alone making decisions. They wouldn't even let him inside the hospital room. So these documents are really, really important. They consist of Your healthcare surrogate. So this is a person who makes decisions for you. If you can't make a decision and you need surgery, who's going to make that decision for you? Your living will, it's different than your will. A lot of people confuse them. So the living will tells people what your end of life decisions are. So if you are in a vegetative state, do you still want a feeding tube? Do not resuscitate and so forth. So that's the living will. The next is the HIPAA form, and the HIPAA form allows individuals that you name to get your to get oral health information from your doctor and to also get written information. So even if you're married and your spouse wants to get hospital records, they can't without your consent. Okay, so this is really important to know because people think, well, I'm married and my spouse can do anything. I don't need any documents. Yes, you do. Everybody does. Um, Also, if you have a child who's in college, they also need to do their incapacity planning, which is get all their healthcare directives in place. Because if something happens, they're over 18, you can't make decisions on their behalf. Another part of the healthcare directives is it's called a pre-need guardianship. Okay, and this is really important. A lot of people don't know about this. They know about the other three, but they don't know what the pre-need guardianship document is. The pre-need guardianship document says that if for any reason guardianship needs to be done for me, okay, so that I'm so incapacitated and my loved one, people have to go to court to get guardianship over me, I am naming these people, okay? The judge can't just come and, whoever just files to get guardianship over me, they get to be guardians over me. No, this is a preemptive strike to say, these are the people that I'm naming to be my guardians. This is really important in blended families because if someone has a child from a previous marriage, they may want their spouse to be the one to be their guardian. And that child can actually go to court and file for guardianship over their parent. And the judge can grant them guardianship, which would completely isolate their spouse. Okay, so this is a really important document to have. The last thing is a financial power of attorney, and there are several types. There's a durable power of attorney, there's a general power of attorney. The durable power of attorney, and they're very different. So a regular power of attorney allows someone to step in your shoes for financial purposes. They can take the financial power of attorney to the bank and do transactions, pay your bills, make decisions for IRAs or 401ks. The interesting thing is that the durable power of attorney withstands your incapacity. A regular power of attorney does not. So this is really important. Some people just say, oh, I have a power of attorney. I got it from my financial institution. Most likely that power of attorney that you got from your financial institution is not a durable power of attorney, which means that if something happens to you, whoever you named in that institution, like if let me walk that back. If you became incapacitated, if something that person you named, it's going to be void. So it's very important to have the right documentation in place. All right. So next, we want to go deeper into this because estate planning is not just about documents. It's very emotional and it's about the people we love and ourselves because we also, want to care for ourselves and love ourselves. Okay. So why do we create life and legacy planning? Number one, it's an act of love for those we care about. This is really, really important. So there was a situation where this individual, he owned a home. He created a trust to put his home in it. And the beneficiaries for the trust were his two adult children. Um, Everybody, and then he decided to get married. Everyone got along, everybody loved each other. But this individual, this gentleman, did not update his estate plan, even after getting remarried. His home and all his assets were still in the name of the trust, and the trust named his children as beneficiaries. They were, living happily for a very long time. Even before they got married, they lived together for 20 years. So this is a long-term relationship. He got sick and she took care of him, and um, he passed away. 1 week. This is serious. Even though, whenever when the husband was alive, everyone loved each other and she took care of him. Literally 1 week after the passing of her husband, she receives an eviction notice from his kids. They evicted her. She had nowhere to go. And it was such a sad situation. She's going to have to go fight this in court. I don't do contested probate. I do probate, but not contested probate. So I had to refer to another attorney, and even that attorney told me it's going to be a battle. It's not an easy situation to get her to stay even for her lifetime. Excuse me 1 second. I need to fix something. Okay. So very difficult situation. Um, yeah. And these things happen a lot. Unfortunately, this year I've gotten a lot of calls, either long-term relationships, living with each other, and getting evicted from the children once the husband or the male, okay, the boyfriend passes away, and unfortunately it's happening to women more than men. So it is an act of love to create an estate plan, a heart-centered estate plan for the people we love. It's also about self-care. So this was a situation where this gentleman, he was started to get dementia, and he discovered that his stepdaughter, his wife had passed, and his stepdaughter was coming to see him a lot and asking about his bank accounts and so forth, and let me help you and all this stuff. And he was feeling uncomfortable. He had a son that lived in a different state, and he called his son. He said, "I'm not feeling comfortable. Can you help me?" He was getting dementia. So his son put him, they found a great place for memory care, and he was there. And eventually things progressed, and he was not doing well. Now, once he got full dementia, he had no capacity to sign any documents. So the son, they reached out to him and they said, has he given you a power of attorney? Has he given you, are you his surrogate? And he said, no. So he said, okay, well, in this case, you're going to have to go to court and get guardianship over your dad because you don't have legal authority to sign anything on his behalf. So the son came to Florida. They did a guardianship. They went to court. He got an attorney so that the son can be his father's guardian. Unfortunately, the son had some credit card debts, like many Americans, many young people, some credit card debts, and he had filed bankruptcy in the past, and the judge said, no, yes, your father needs a guardian, but I'm not having you be his guardian. I just don't think you're fit. So this is a judge. He doesn't know the character of the son. He doesn't know his love for his dad. He has no idea about anything. And this judge put in a court-appointed guardian for his dad. Court-appointed guardians get paid a whole lot of money. The last I checked, they get either $150 to $200 an hour. This court-appointed guardian started filing things in the court for billable hours. The first thing that he did is he took the dad out of this really nice nursing home, put him in a really not so nice nursing home because it was cheaper, and he told the judge he's preserving the money because this gentleman does not have enough money to stay in that facility. What he was really doing was reserving money for himself. At the end of the day, all the money was depleted, and the father died, and it was a really sad situation. Father would not have intended for all his money to be passed like this. Medicaid planning could have been done, by this guardian, court-appointed guardian, which he did not do. It was a very sad situation. So for self-care purposes, it's so important for us to do these, put together these documents and name people that can step in our shoes if we cannot take care of ourselves. The last thing in this section that I want to talk about is control. Okay. We worked hard for our money. We want to be in control of where our money goes after we pass. Okay. I am an attorney. I'm a control freak, just a little bit. I like to control things. I want things to be done just the right way. Now, without meaning to do this, our assets can wind up with people who are not even related to us and we don't even know. So let me tell you this interesting situation where grandfather, okay, he was a wonderful man, and he said, upon my passing, I'm giving my home to my granddaughter. Everybody loved his granddaughter. She was the first granddaughter in the family. All her cousins loved her. Everybody was completely okay with this. Granddaughter was married, and everybody loved her husband, great guy. Now, grandfather passed, granddaughter inherited the home in her name, right? Now it's her home. And without having children, she passed away. Guess who inherited the granddaughter? Her husband did. Now her husband owned the home, and her husband got remarried and had a family. Now, once he got remarried, the family went to him and they said, this was not the intention of grandpa. Okay, he did not intend for you to get the house. He wanted it for his granddaughter, and he expected her to have kids and generation after generation to live in this house. That was the intent. Can you please give us the house back? And he said, no, it's my house. They tried to take him to court. The attorneys told him legally he has a right to that house. And if you went back and told grandpa this is going to happen, he was going to say, no, I would definitely not wanted this to happen. So there are ways of creative estate planning that would have completely prevent this from happening. Okay. So let's talk about probate. Now, a lot of people hear a lot of things about probate, that it's a taboo. Probate is horrible. It's not the best thing to do. Okay, I'll be honest with you. It's not the best situation for a few reasons. Number one, it's lengthy. It takes 3 to 6 months for probate to happen in the court, and it's 3% of your assets. And like I mentioned before, it's public record. So the will that you created that says the names of your loved ones and what percentage goes to who is public record, and everybody now knows who to go after. We've got a lot of strange people out there, and they have their reasons why they go and get, wills that belong to people. They look them up. And start targeting people because they just inherited a lot of money. And when someone passes away, and this is extremely important if you're single, but also important if you are married. So when someone passes away and they have an account in their name, that account gets shut down if it's not, even if you have beneficiary designation. Okay, this is really important because some people's like, but I have a beneficiary designation. What happens to that account? First of all, it gets shut down. Okay, number one, until your loved ones get your death certificate. My dad recently passed away in February. It took about a month and a half to get the death certificate. This is really long. It used to take about a week. I'm not sure why. Nowadays, it's taking a really long time for loved ones to obtain the death certificate. So a month and a half has passed, and the accounts are shut down. And if probate needs to be done, you need to pay an attorney. You need to pay funeral expenses. That home that your loved one owned, the lights need to be paid, FPL needs to be paid, the water bill needs to be paid. The credit cards need to be paid, the hospital bills need to be paid. So there's a lot of expenditures that are going on. There's a lot of money that needs to be paid, and all the accounts are shut down. Okay. So that's something really, really important. We're going to actually, talk about where does that money come from in a little bit. So what does 3% of your assets mean? Okay, so I did a little calculation here. Family home, 600K, stocks, bonds, bank accounts. I know a lot of you have retirement accounts. Let's say it's $1 million estate, and now it has to go through probate. That's $30,000 just attorney fees. How is that calculated? And who tells the attorney that that's his fee? Well, there's a Florida law. There's a statute that actually tells attorneys how much they can charge. And it's quite high. And the reason being is that anything in court is annoying. Let me tell you, we don't like to go to court. I prefer doing planning with my clients. So and there's, 3 to 6 months being in a case is a long time. So there's also other fees. There's court fees. If there's an issue with life insurance and the attorney has to be involved, that there's going to be fees for that. Retirement accounts, if beneficiary designation is not done right and the attorney needs to be involved, that there's going to be a fee for that. If there's a business involved, okay, even if the business has nothing, is making zero money, the court's going to require a business appraiser to get involved, and there's fees for that. There's also CPA fees. So if you can imagine, it can get very expensive to do an estate plan through probate. And as I said, the accounts of someone, if they have an account in their name, not a joint account, okay, what happens? It gets shut down until either probate happens, or if there's a beneficiary designation, they have the loved ones who are named as beneficiary designation, they must take the death certificate to the institution so that the institution can give them the assets in the accounts. One thing I will tell you is that I recently did a probate case for this woman. Her parents had a joint account. Mom passed away first, then dad passed away, and dad had put his daughter as a beneficiary designation. She went, and this was a prominent bank. She went to the bank and they told her that the beneficiary designation was dropped. She had paperwork and told them, I mean, she showed them and they said, yeah, sorry, we don't see in our system. Now, when that happens, is she going to go sue a bank? She's not going to go sue a bank. She has to hire an attorney, pay like what, $50,000 to sue the bank. It's not going to happen. Banks make mistakes a lot. Financial institutions make mistakes, and no one's going to go sue them, and they know that. So we had to do probate for her. It is what it is. That was the situation. So just wanted to share that with you, that this does sometimes happen where banks and financial institutions do drop beneficiary designations. All right. Where does the money come from if my accounts are shut down and it's taking a while for that money to be transferred? Okay. Well, this is statistics from last year. It's going to come from our family, right? It's going to have to come from somewhere. 54% of respondents, they say they had to, pay money from their own sources. 52% use credit cards, because that's a lot of money that they have to pay. And a lot of people don't just have, a lump sum of money just in case their parent passed, right? To pay out. Some people had to borrow money from banks. 39% took their money out of their own investments and they had to sell things to pay for their loved ones, estate administration. 30% borrowed money from family and friends. And like we said, a good estate plan is about, it's an act of love for our loved ones. So just I want to pause here and explain something really important. So some people say, okay, you know what? Instead of that happening and the account gets shut down, I am going to include one of my children on the account. I want to tell you this is really important and the danger of this, okay? I had a situation where this woman called me and she said, I would like you to assist me and my dad. And I said, sure. And she said, well, instead of doing estate planning, my dad put my name on all his assets, his bank accounts. He also has a rental property, and I'm on the deed. Can you please take me off of the deed? I said, okay, interesting. Why? What's going on? Because, of course, someone asking that, something is going on. And she said, well, my husband had a car accident and he killed someone. It was my husband's fault. And now they're going after my dad's assets because my name is on it. And I said, well, I am so sorry to hear that. I mean, it wasn't even her fault, but she's on her husband's policy. You're married, you're on the policy together. I said, unfortunately, that would be fraud. I would get in trouble. I would get reprimanded. Like, I don't know, I have my license to think of. I would never do that. I can't do that after the fact. And this is fraud. And anyway, the judge would unravel everything you're doing because you can't do that. They can get evidence of everything. There's a deed with your name on it. There are bank accounts in your name. I'm not going to be able to help you. And she realized the situation. So I don't recommend at all putting anyone, unless you're married, putting anyone on your assets because think of it this way, their creditors are going to be your creditors. Okay. So very important, please, it's not worth it. The only okay thing that I tell my clients is that if you have an in and out, I call it an in and out bank account, which is, I have, some people, they have one of their children doing their bills for them. So they put them on the account and which allows them to pay their bills. But everything that's coming in and out, in and out, the account has hardly any money. It's just for paying the bills, and whatever's coming in monthly is paid out by the end of the month. This is the only thing that I would say is okay to have somebody else on the bank account. All right. So some of you told me you have grandchildren, and some people like to give something to their grandkids. So let's talk about this. This is really, really important. Without an estate plan, if a minor child inherits more than $15,000, so minor kids can't inherit, right? Like kids can't own property if they're under 18. If it's if it's less than $15,000, so their guardian, whoever it is, their parent they will take that money for them on their behalf. If it's more, then their parents have to go to court. Okay. And the judge is going to decide on which parent is going to be the guardian over the money. And every year, the parent has to submit a ledger to the court and to show how the money is being spent. It's so intrusive in so many ways. Okay. And this happened because you probably heard about child actors whose parents abused their money and so forth. So these laws came up that anything over $15,000, a judge has to approve who the guardian over the money will be. But this is the difficult part. Upon the child turning 18, they get all the money. Okay. And this is what I was saying. An 18-year-old is just a number. It's not a sign of maturity. We have no idea that 18-year-old, can they handle money? Especially we have some grandparents leaving certain life insurance policies for their grandkids. Now, imagine an 18-year-old all of a sudden having $200,000 or more in their hands, cash, liquid cash. I know someone who inherited $25,000 and he was in college, dropped out. Of course, all of a sudden was very popular, had a lot of friends, partied, and then lost it all within a very short time, found himself completely alone and decided to go back to college, but he lost 2 years of his life by the time he went back to college. So, and thank goodness he woke up and went back to school. Okay. Some people don't. Some people, money can really be dangerous for young individuals. So in order for that not to happen, there are very creative and wonderful ways we can do in a trust. to prevent all these things from happening. Another thing is, I don't know, some of you may know the Florida Department of Unclaimed Funds. This is an account that belongs to the state of Florida. And the last I checked, it had almost $3 billion. Guess what this money is made of? It's individuals who passed away, whose loved ones had no idea had accounts, bank accounts. Okay. And this is very, very important so this is what happens. Let's say I have a bank account with Bank of America and I pass away. Now, a year goes by, another year, and then my loved ones have no idea that there is a bank account in my name with Bank of America. What happens next? So no movement for year one, no movement for year two, maybe year three, and somebody discovers this bank account. Oh, wait a second. Nothing has been in and out, like nothing, no movement, no activity on this account for 3 years. Let's send a letter to the last known address. So by that time, the house has been sold. The new people get the letter. Either they say return to sender or they throw it in the garbage. Most likely they throw in the garbage. And the bank just sits with the money and is like, okay, nobody claimed it. We give it to the state. And right now, that's a whole lot of money. Okay. And it's not easy, actually, if it's a big amount to take your money out of the state's clutches, I call it. There was an article in the Sun Sentinel with this woman who discovered that her loved ones, when her loved ones passed, he had money in this unclaimed property fund, and she had a really hard time getting the money out. Okay, so this is not an easy thing as well. All right, so we talked about what a lot of things that could happen. Let's talk about what a trust is, not just a regular trust, but a fully funded living trust. Yes, I have a picture here of a shopping cart, and I want to explain it in a simple way, okay? Because trust conversation can be quite complicated. Let's say you decide to go to a supermarket, but you say, you know what? I only need a couple of items I'm going to carry in my arms. I don't need a shopping cart. So you're carrying eggs, you're carrying a glass bottle of juice, you're carrying bread and, some fruits, and you're carrying all these things in your hand, and you're going to the register to pay for it. And you slip, and all these things go flying in the air, crashing on the floor. The eggs are a mess. Everything is a mess. You're on the floor, and it's a big mess, right? Imagine, on the other hand, another scenario, you decide to go, even though you don't have a lot of things, you're going to take a shopping cart. You're going to put the same things, the eggs, the bread and the fruits and the glass, everything is in there. And you're pushing your cart and you slip and you fall. Okay. What happens to your stuff? It's intact. It's protected. Someone else can come and push your cart and pay for it and take care of it and on your behalf. That is what this is, a simple way of looking at a trust. But you notice I wrote there a fully funded living trust. And that fully funded is extremely important. Because I review individuals' trusts all the time. And a lot of people would come to me and show me their trust. And I say, okay, did you retitle your bank account in the name of the trust? And they're like, what are you talking about? I'm like, okay, wait a second. Is your home, has your home been retitled in the trust? Anything happened? He's like, no. And I asked, okay, how about investment accounts? Like, no, everything is in my name. I'm like, okay, well, you have an empty trust. Like, what do you mean? I said, you're going to go through probate. And they're like, no, I created a trust. I should not have to go to probate. Well, it has not been funded. You have an empty shopping cart. Okay. There's nothing to pay. It's completely empty. All your stuff is still outside the shopping cart. It's not protected. So this is something very important for those who have trusts. They got to make sure that their trusts are fully funded, which means that they have been they retitled their assets in the name of the trust. The only thing that does not get retitled in the name of the trust are IRAs and 401ks, and they're treated a little bit differently. All right. Now, we talked about a lot of things. What do we do? What's next? How do we protect ourselves? Okay. Well, before that, let's talk about, I touched upon this, but let me delve a little bit more into it. If you already have an estate plan, okay, these are important things to ask yourself. When was the plan done? Were my children still minors and now they're married, right? If that's the case, your plan is not going to work for you under another state law. So if you moved from New York, we got a lot of New Yorkers moving down, and from other states. It needs to be updated to match Florida law. It's really, really important. It will, some banks won't even accept out-of-state estate plans, especially the durable power of attorney. Was the plan updated after a life change happens? So did I get a divorce? Did I get married? Did I get separated? Imagine being separated and your estate plan is naming your estranged spouse, okay, estranged spouse, to make healthcare decisions if you can't. That's a horrible thing. You know, you don't want to put yourself in that situation or put the other person in that situation. They may not want to. Okay. Um, how about, a family member that you named in your estate plan that died? Or now there's someone in there that you had a falling out with. Okay. Birth of a child, you bought a new home, a child turns 18. So there's a lot of things that would cause your estate plan to be updated. So these are very important things to think about. All right. Now, Um, I want to talk to you about traditional estate plans, and I want to talk about life and legacy planning. Okay. I don't do traditional estate planning. I do life and legacy planning. And I want to explain the difference between both. Traditional estate planning is the attorneys, they focus on the documents. And this is what we hear in the media. This is what we read online. It's about the documents. And a lot of people call me like, I want to create a will and I want to do this and that. And about the documents, I want to do these documents. Yes, estate planning is, the documents are a byproduct of estate planning. I want you to understand the difference. Traditional estate plan, you go to an attorney and you say, okay, I want everything, when I die, I want everything to my spouse. If I don't have a spouse, I want it to my kids or these people. And we call it a day. Okay. And the attorney, the traditional estate planning attorney says, great, let's do it. You come in the next time, you're signing documents, you're given your binder, and that's it. Life and legacy planning is different, where when you come and we sit down, we talk about your family dynamics. And when you tell me this is what you want, I tell you the consequences of your decisions. Whereas with traditional estate planning, they're doing what you want, right? They're not doing anything wrong, but you have no idea the ramifications of the choices you made. So for example, if you are married and you are in a blended family, you have children from a previous marriage, and you say everything to my spouse, you can be disinheriting your children without knowing it. Okay, I was just recently talking to a couple that did just that, and they had no idea. They got shocked. Like when I explained to them how this happens and what could happen, where their individual children or one, they had two sets from previous marriages, and they could have been completely disinherited. So when we meet, we talk about your family dynamics, and you make choices from a place of power, from a place of knowledge. Okay. Next, the relationship ends once the documents are signed. So signed documents, here's your binder, here your goodbye, and that's it. For my clients, I have a complimentary meeting around the 3-year mark, because in 3 years, a lot of things happen. And I call my clients like, let's have a meeting and let's see if this plan still works for you. Okay. And to my surprise, well, to their surprise, they like, oh, this happened. And they sometimes people don't even look at their plan and they forget who they named in their estate plan. And they discover, wait a second, I need to remove this. I need to change this person. I need to do that at that 3 year mark. But I always, of course, tell them anything that happens within the 3 years, please come and talk to me because we want to make sure that if something happens, this plan still is the right plan for you. Assets are missed and end up with the government, right? Whereas with my clients, we create an asset table and we put all their assets in there. And this is something they have to keep up. And with selling assets or obtaining more assets, it keeps my clients so organized and they love it because it calculates their net worth. It's a really cool table that they have and it stays, with them or they can share it with loved ones and it depends on what they want. But if something happens to them, it's available for their loved ones to be able to manage their assets. Money goes through probate court. And again, probate, yes, it's not fun. It's not horrible. I mean, it's not absolutely horrible. It's, people go through it every day, but a lot of people want to avoid it because they want things to be easy for their family. They don't want their loved ones to go through that and for their loved ones to pay all this money outright and until they get paid and so forth. It's a tough time. When my dad passed away, it was such an emotional time. It was so difficult for me. And to be able to also have to deal with so many legalities as well, it's hard. We want to make things as easy as possible for our loved ones. Um, Again, guidance in retitling your assets. So, uh, when for my clients, we go through the different type of assets, and I give them the documents, and I give them instructions. For the bank, this is what you need to do. For this institution, I give them complete guidance on how to retitle their assets in the name of the trust. And if they can't do it, I can do it for them for an extra fee. But most of my clients are savvy enough to do this for themselves, or they have their children help them to save a little, some of the money. But I give them this guidance and I continue to give it to them until our last meeting so that they can retitle their assets in the name of the trust. Again, we create a trust that's really tailored to them, okay? So that their assets are not inherited by people they don't know. So how do we start this? Oh, okay. First, we create this estate plan. The goal of a good estate plan is keeping our families out of court and conflict. So where do we start and how do we do this? The first step is not just a regular consultation. It's a life and legacy planning session. So this is a session where you would come and talk with me, and I allocate about an hour. I allocate 2 hours for this session. Most of my clients take about an hour to an hour and a half. Some people take the full 2 hours, but I allocate 2 hours so that I don't like to rush anybody. We need to have that back and forth conversation. I need to ask follow-up questions to really understand your specific situation. During this meeting, my clients get very financially organized. Okay. We make sure that their assets don't wind up in the unclaimed, with the Florida state. They make informed decisions from a place where they understand what the law is, because I understand the law and they understand their family dynamics. And then when they explain it to me, everything, meets up and we can create this wonderful estate plan to keep their family out of court and out of conflict. We have a lifetime relationship. Again, I'm there to support their family and I'm there to support them. Everything is flat fee. No, when we sit down and you get to choose the level of plan that works for you and your family, and everything is flat fee, there are no surprises. All right, so I told you I'm gonna be giving you a gift for coming here. You gave me your time and I really appreciate your time. We're almost at the hour, but I will also be taking questions. So this is your gift. This Life and Legacy meeting with me is $750. I am incentivizing you. I really would like to encourage you to get this done for yourself and for your loved ones. So I'm not going to be charging for this meeting because you came here today. And if you book this within before next Friday, so this coming Friday is the deadline. I'm also going to give you $250 off of your estate plan. This is $1,000 value attendance gift for you. So this is my information. I'm also going to put in the chat the link to book this life and legacy planning session with me. So a couple of things about this session. If you are married, you both need to attend this together in order to get the free meeting and the 250. That's one thing. And also this meeting is going to be virtual. If for some reason you don't like virtual, please email me and let me know that you prefer to meet in person, and we'll meet in person. I'm not against it, but I find a lot of people with that first meeting to do this virtually. It works great, and we can actually design your plan should you move forward during that meeting. Okay, so I'm going to stop sharing, and I'm going to put the link. Give me 1 second. I want to put the link in the chat before taking the questions. Okay, chat. Okay, so, and as my contact information. So on top here, this is my calendar link for the Life and Legacy Planning session for you to book that appointment with me. Okay, so let's go. Please put your questions in the Q&A. I see a bunch of questions. Let me see. Okay, regarding the HIPAA form, so it's different. Some doctors have it. Some hospitals have the HIPAA form, but I have my own, and it's a very robust form um, that I do for my clients. So sometimes doctors would have it, but the legal form that I provide is, from attorneys. It's going to be more robust. Okay, so let me. Okay, so it says, in Florida, doesn't your property taxes rise when refiling home as a trust? No, it does not. Um, because you're giving it to yourself. Okay, and when I create the deed, I do say that this is your homestead, and inside your trust, there's also language that this continues to be your homestead. So no, it does not. There's no issues with that. Okay, okay, do you serve as an executor, or would we designate a family member? You would designate a family member. I have a lot of my clients want me to be their trustees and their executors, but unfortunately, that's something I cannot do. Actually, they're ethically too. So just to give you a background, there were attorneys naming themselves as trustees because trustees get paid. And the Florida came to say you can't keep doing that. You have to give them informed consent. And so it's a little bit complicated when the attorney who's drafting also is your trustee and so forth. So it's important it's good to name a family member. If you don't have a family member, you can name anybody. You can name someone who's a professional. I also know some of my colleagues, they're really good people. They are willing to be executors for people who don't have anybody, and trustees as well. So that's something that I can assist with, but I cannot be an executor. Next question. I am a single mom of two children and townhouse. Okay, so I'm a single mom with two adult children, and her asset is that townhouse. Should she has a ladybird deed set up? Um, I th well, interesting question. Not just a will. You're a single mom. You need to set up incapacity planning. Okay, which is your revocable, which is the durable power of attorney and all the healthcare directives that I talked about. These are really, really important to have in place as a single individual. Even married, like everybody should have these documents, but I would stress that you would definitely need those. And it's not a bad thing to have a will. Sometimes, we come into money or we have a bank account or something that needs to go through probate. I always recommend a full estate plan, but you should have at least the incapacity planning done for you, because even though they're your children, they may not be able to get your healthcare information from the hospital and the doctors, and definitely they're not going to be able to get to your bank account to help you with anything. Okay, can you do? Okay, out of the country assets and beneficiaries. This is important. Um, Even estate planning that's done in Florida and it's US based, assets outside of the country are going to be managed by the laws of that country. Okay. Not all the estate planning documents that are created in Florida are accepted by other countries. In term of beneficiaries in other countries, the United States has treaties with different countries regarding taxes. Yes, beneficiaries in different countries you can name them, and I've done that for some of my clients, but also there's a withholding of taxes on certain money until the taxes are paid in the other country. And if you tell me the specific country, I'm not going to know. So each country, literally, this is a question for a CPA. Each country has a specific treaty with the United States on how much taxes to withhold. So, and assets in another country, even if we name them in a U.S. trust or, in your estate plan in U.S., documents, the other country may not accept them. So I always recommend that you do estate planning according to the other country's laws as well. So dual estate planning. Okay. What is talking about my fees? They're asking about my fees for an estate plan under 500,000. So it's not based, my fees are not based on your net worth. They're based on what you want to accomplish. My fees start at $3,000 and they go up depending on what you need done. So that being said, I have individuals who have, you know, less than $100,000 or around $100,000 in net worth, and they want to do a trust because their children are going to either get hurt or hurt themselves if they get the money outright. So we need to create a trust for them. So it's not about your net worth, it's about what you need and what you find value in. So somebody who has very little is gonna, she was very worried that her children are gonna get that money and hurt themselves with that money. Okay, so she wanted to create a trust. She wanted to put a trustee in charge of the money and to give the money, in specific situations for her kids. So it really is not based on your net worth. And I have individuals with multi millions of dollars and they're charged the same because I'm doing the same exact work for them. And sometimes I have individuals who are, who don't want a very elaborative plan as well. So it really depends on what you want. Right. So thank you for sharing where the country is, but that country may not accept documents done in the United States. I do suggest you go to that country and do a state, go to an attorney in that country and have that attorney create a plan for you according to that country's laws. Who are not married but live together. Okay. Okay, so this is a great question, and this is happening a lot right now, and a lot of problems you know are happening. So this question is adult partners living together with commingled assets and some investment properties and so forth. Yes, we can create an estate plan. You each need to create your own estate plan and name each other's as the estate in the estate plan. There are ways to do this, especially if you live together and and that home where it goes, is it going to go to 50-50 to to different individuals or your loved ones, or where will it go? So this is a conversation we would need to have. This is not just an easy question. You can definitely create an estate plan to service that situation. Last question. Two sisters that live. Okay, my mom has dementia and she lives in Georgia and I live in Florida. I have two sisters that live in the same state of Georgia with my mom. Should I get a POA or should my sister get one? Okay. If you're talking about your mom, a POA for your mom, it's too late. She has dementia. If she has lucid times and she knows what she's signing, she can give you a POA or your sisters. Um, but if she has no idea what she's signing, that is an invalid power of attorney. Um, so this is something really, if you're talking about, yes. And if you're saying that should you get a POA or should your sisters, it really depends on who's doing most of the work for your mom. Okay. If she is lucid sometimes and if she realizes what she's signing and an attorney, because the attorney that's going to be doing this in Georgia is going to have to, this is also his license. So she must have capacity to sign in front of notaries, in front of witnesses as well. If you're doing some of the work for her, so I do suggest, yes, maybe a power of attorney for you. But if and your sisters are doing most of the work for her, then they should be powers of attorney. Wait, okay. Mom owns her apartment and it's two siblings. What's the best way to avoid probate? So this is a type of deed. It's called an enhanced life estate deed. A lot of people also call it the ladybird deed. This would allow her a life estate to live in her home for her lifetime, and then it would pass to whoever she names outright to them. It's just the only thing that sometimes I'm not crazy about and it's not clear is, so if there's two siblings and one of them passes, the other 50% and may not, and attorneys argue about this all the time, may not be able to be passed down to that person's, the deceased family, and where the other sibling may just, own it outright, the whole property. So sometimes that happens. I know it does happen with designating beneficiaries with bank accounts. Banks are just, they don't want to be bothered. So if you're naming two of your kids as beneficiaries and one of them passes, the bank is going to give it to the other one. The one that passed, if you've got grandkids, they're not going to get the money. The bank doesn't want to be bothered with that. And that's why they say, create your own estate plan. We're 3 minutes over, so I will take one more question. I want to thank you so much for being here. And I see a lot of people, um, a lot of people here. I'm gonna read the chat really, really quick and see if you have more questions, please email me. Okay, my information's in the chat. Let me just put it one more time. Let me paste it again for anybody who wants it right now. And if you have more questions or you want to even have a quick conversation with me, just email me and we can talk some more. All right. Have a wonderful rest of your day, everyone. Thank you so much for being here. Take care.